the debates organised jointly by the Institute for Fiscal Studies and the Chartered Institute of Taxation. I'm Ray McCann. I'm the President of the Chartered Institute of Taxation. I think this is the second one of these events I've chaired. We have to speak, apparently for the live stream which is running tonight, and some people are following it on the internet, we have to speak very close to these microphones, so that will sort of get in the way a little bit, I expect, from time to time. No doubt one or other of us, or all of us, will forget. Just to start off, some apologies on behalf of Kelly, who has unfortunately been taken unwell. She is on the road to recovery, but I'm sure you'll all join me in sending our best wishes to Kelly for a speedy recovery. The other apology is from Nicky Morgan, who has been unavoidably detained in the House. I was sincerely hoping that the word Brexit would perhaps be off limits tonight, as we were not discussing anything to do with Brexit, I hope, but unfortunately it seems that Brexit has delayed Nicky. But she is hoping to get here, and hopefully she shouldn't be delayed too long. Unfortunately, that means that we've got a sort of enforced manel on us at the moment, so I hope the Twitterati don't start blaming me. Talking of which, Keith Gordon, who many of you know, a barrister, is eagerly watching this through the live stream and will no doubt contribute various questions at time to time. So as a consequence of that, I have agreed with Keith that I shall watch for questions coming in on Twitter. Therefore, if you see me looking at my phone from time to time, it doesn't mean I've lost interest, it just means I'm trying to keep up with what people are saying. I'm sure the two gentlemen on either side of me need no introduction whatsoever. There is a bio in the little booklet that you've got, but Malcolm Gammie is a past president of the Chartered Institute of Taxation. He's a very distinguished Queen's Counsel. Sir Edward Troup. Edward and I had a little bit of overlap in HMRC, not much, but some. And he is also a very distinguished lawyer, but equally public service, almost through and through, but not quite. HMRC's first Assurance Commissioner in the wake of various things that were going on some years ago. Retired from HMRC a year ago, now consulting, and I'm really pleased that the two of them are here because hopefully once Nicky arrives, and with Kelly, I hope, watching on, it's a stellar of all stellar panels. The way we're going to start is Malcolm is going to kick us off. Edward will have his own presentation. Perhaps he'll respond to Malcolm. I'll make some comments which are based on what Kelly would have said, which I don't think is too inappropriate given that from time to time I've worked with tax help. And obviously during my presidency I've been very keen to emphasise the need to make sure that we look after those who are unable, for whatever reason, to look after their own tax affairs. So much of what Kelly was intending to say, I probably would say if it had been me that had been in the slot. Then we'll throw it open to you, and hopefully we'll get a good question and answer session. Feel free to ask questions, and we'll take it from there. Malcolm.
Well, good evening, everyone. I assume that the microphones here will carry to whoever's listening outside the room. So this evening's session is really born of two things. Firstly, a report that the Tax Law Review Committee of the Institute for Fiscal Studies published now a little while ago. In case you haven't seen it, I'm sure it's on their website to download, which looked at the balance between recent additions to the revenue's powers and the balance in the relationship with taxpayers. And then more recently, as I'm sure many of you are aware, the House of Lords Economic Affairs Committee looked at the issue of revenue powers and published last December a report, The Powers of HMRC Treating Taxpayers Fairly, which included a variety of recommendations. So that was the catalyst for this evening. So I wasn't quite clear when I saw the advertising and indeed the title of this session as to whether it quite accorded with what I thought I was going to be talking about. What I had wanted to focus on was the issue of revenue power. And you'll see I put in a subtitle there, Does HMRC have too much power and too little supervision? The questions for the for the advertising for this particular evening, asked a number of questions, which I have put on this slide and to which I've put some answers. So what are the responsibilities of taxpayers? Well, as a lawyer, I'm going to say to pay tax as required by law. What are the responsibilities of their advisors? Again, I'd say to advise taxpayers on their responsibilities. In other words, what tax that they must pay as required by law, and to assist them in complying with their responsibilities. That I see as the principal role of advisors. And then, do those responsibilities change in an environment of pre-populated digital tax accounts? That was the next question on the advertising, to which I would just say no. It doesn't seem to me that it does. Of course, one can recognize that the balance of things might change if the revenue send you a pre-populated tax return or something like that. But ultimately, I would have thought the revenue will assert, and the courts might well be likely to hold, that it's your responsibility to check that the revenue have got it right. Not that you can just rely necessarily on what they've put in their pre-populated returns. So they were the advertised questions. Actually, I'd say there were some missing questions from the advertisement. So what are the responsibilities of HMRC? That seems to me to be the focus of what we should be discussing here. And it's interesting to note that in the House of Lords report, they note that in the 2016 publication of the Charter, it appeared that the responsibilities of taxpayers had increased and the responsibilities of the revenue had decreased, according to the Charter, or at least that's what the House of Lords report draws attention to. And then I think we should ask ourselves, to whom are the revenue accountable for the way in which they fulfill their responsibilities? Because that's really what I think is the fundamental question. The revenue, we shouldn't just think it's all a matter of the taxpayer's responsibility. Actually, the revenue have a degree of responsibility, and the question is, who is it that holds them to account for the way in which they fulfill their responsibilities? I also pose the question, to whom do we think the revenue should be accountable? So they're the sort of questions that I think we should focus on. I'm not necessarily going to provide, much to Edward's disappointment, I'm not necessarily going to provide you with all the answers in these introductory remarks. There's a wealth of experience out there in the audience. I'm sure you've all got your own views, not only about what the revenue's responsibilities are, but how they currently exercise them and how they should be held accountable for the way in which they do exercise them. And I'm sure that may fill some of the question and answer sessions that we will have in due course. So that's where I would put the focus. It's not just a matter of the responsibilities for taxpayers. Of course, taxpayers have responsibilities. But actually, I think the focus of the current debate should be on the revenue's responsibilities and how they are actually supervised and how they are actually accountable for the way in which they fulfill their responsibilities. Now, I thought it might just be useful to remind ourselves of some of the additions to the revenue's discretions and powers over the last few years. This is all essentially over the last 5 years or so, and it seems to have become a lamentable bit of finance bills that they seem now to have an administration section to them. So previously you had finance bills and acts divided up into income tax, corporation tax, capital gains tax, various taxes, direct taxes, indirect taxes. Now we always seem to have something about revenue powers and administration and the like, which may be all right, but on the other hand, it's just an encouragement to think of new things that we should be adding to the list, that we might think that that's not necessarily ideal. I pose that as a question. It may be that the revenue do need their powers and administrative abilities added to every year, year by year, but it seems strange that we've managed to go so many years without having that we suddenly seem to need it on an annual basis. Anyway, so where have all these new powers come from? Well, I've started off with the general anti-avoidance rule, to which, of course, we have to add regime anti-avoidance rules and targeted anti-avoidance rules, which are not really targeted at all. They're all in general terms, all of which add actually significantly to the revenue's powers. If you want to contrast the past with the present, of course, the past tended to operate and this is maybe, some people would say, would be the vice of the British tax system on the basis of legislation which tried to write exactly what should be taxed or what should not be taxed. But we seem to have gone away from that and decided that actually we should have a lot of uncertainty around the edges of the tax system. We might think that's good, bad, or a new way of doing things, but it certainly adds to a degree of discretion for the revenue, and I might add that, of course, the UK is one of, I suspect, I haven't done an international survey of this, but I suspect we're one of the few regimes which doesn't have a formal rulings procedure of any sort or any general coverage for the tax system, which a lot of other countries do have, which, of course, is something which you have to think of in conjunction with the discretion and uncertainties of legislation. Anyway, so what else have we got? I'm not going to run through all of these. So these are just sort of bank code of practice, government procurement policy. I know of a case a few years ago where a taxpayer abandoned their appeal because they were frightened they wouldn't get picked for government procurement, and I can think of another case there. We might think that's good or bad. Bank code of practice and government procurement policy are, of course, all soft law issues. They're not really matters of hard law, legislation, or anything like that, although bank code of practice has got a legislative element to it. But it's all ways in which taxpayers can be persuaded to follow particular courses of action, even though it might not be strictly in line with the law, or at least they might not be. They might deviate from what they could actually do to what they feel it is sensible to do. We might again ask ourselves whether that is appropriate, but more particularly we might think about it in terms of where the revenues, responsibilities, and where the supervision of the revenue actually lies. Then we have follower notices, which were a particular issue addressed by the House of Lords. I did give evidence to the House of Lords about this at the time that they were looking at this before they published their report, when they were taking evidence. As some of you will know, I acted for the revenue in a case called Eclipse 35, and one of the recent follower notice cases has been the revenue saying that Eclipse 35 means that they can issue a follower notice for a point that was never argued in Eclipse 35, which you might think was not quite the object of the follower notice legislation, that effectively the revenue should use a follower notice to attach a penalty to someone who wants to argue a completely different point, but it happens to be by reference to a similar scheme to that was used in Eclipse 35. And then there are accelerated payment notices. Well, of course, again, you may think that it's quite appropriate that the person that should hold the tax while matters are being argued about is the revenue, and I'm certainly not going to argue that that's inappropriate. There'll be views around the room about it, about how it's acted or how it's operated, as many people have seen it retrospectively, but going forward, looking at it in a forward perspective, you might say it's perfectly appropriate for the revenue to hold the tax while matters are argued about in particular cases that are defined. But actually, and I don't necessarily, as I say, I don't necessarily disagree with that, but you might think that actually then the revenue have got some sort of obligation to get a move on with some of these cases. And if it's merely a reason for them to sit on their hands and not take far too long over inquiries, you might think that's entirely inappropriate and something that shouldn't happen. And then you've got things like promoters of tax avoidance schemes, serial tax avoiders and the like. Again, you can say, well, the people who are really to blame, and indeed the House of Lords say so in their report, that there's far too much targeting on taxpayers who were not sophisticated enough to understand what they were doing, but very little action that seems to have been taken against promoters of these schemes. one doesn't really necessarily know what action's been taken against promoters. But of course, these are all cast in hugely wide legislative terms, so that you might say they're capable of going far beyond what is actually the initial target of those particular provisions. And again, does the revenue have a responsibility to operate those provisions in a way in which they were originally intended and put to Parliament, and who should have the ability to oversee exactly what it is the revenue are doing and how they're exercising these powers. I won't, well then there's enablers of offshore evasion and non-compliance. There are lots of other things. Enablers of tax avoidance arrangements. I obviously have an interest in that, seeing it's targeted at people like me. When I say people like me, professional people around this room. If you start telling taxpayers they can do things which the revenue think go beyond the pale. Increased use of penalties and changing the burden of proof. I mean, it is one of, again, something in the House of Lords report, but something which I also notice in the cases that come to me for my advice, that, you know, you almost get the sense that the revenue's attitude now is that if you happen to disagree with their view of the law, then you must have been negligent or, you know, sort of guilty of unreasonable behavior of some sort, and therefore they need to ask you whether, you know, whether in fact you think you're liable to a penalty, or they might suggest that you're liable to a penalty, which is not quite what I think should necessarily go on, but again, there's comments about that in the House of Lords report. And then we've got extension of offshore time limits, which the House of Lords, of course, specifically said the government should drop from the Finance Bill, but which was, of course, included in the Finance Act that passed on the 12th of February 2019, so a couple of weeks ago. That extends to 12 years in relation to the time limit for raising assessments in relation to offshore matters. Time limits for assessments, again, from my experience, is becoming an issue. When you're a litigator, when I spend my time litigating, of course, what's absolutely crucial in a huge number of cases is your ability as a taxpayer to bring evidence to the tribunal, because ultimately the responsibility for displacing an assessment the burden lies on the taxpayer, not on the revenue. That becomes extremely difficult, or more and more difficult as time goes by. I'm currently litigating many cases which emanate from at least 10 years ago, and you know, that can be a big problem. And I even have one or two cases where the revenue say, well, we know you told us all about this, but actually we think you didn't make the right return, so we can go back 20 years on this. So the issue of taxpayers being able to rely that they have finality in their affairs, and the difficulty that may face taxpayers in resisting assessments which go back many years should not be underestimated. Again, the question is, what is the revenue's responsibility in this particular field in operating these powers that they've been given, and who should have the ability to see how they're using them and actually not necessarily always call them to account, but draw attention to what it is that they're doing. Okay, so some points to consider, and then I'll conclude. Well, not to be too optimistic about this, don't count on Parliament to limit revenue's powers. I mean, we've seen for the last 5 years they'll give them anything they ask for, broadly speaking. And you know, so the constraints, in a sense, on what powers the revenue got are their own judgment as to what they can ask for, I suspect. That, again, I'm putting some of these points out for discussion, and I'm sure Edward will have comments on them. Once granted, a power is quite unlikely to be withdrawn or restricted. I almost said never withdrawn or restricted. You've only got to look at the powers that Customs and Excise had in their day. I always remember when I first worked for the CBI back in the 1970s, the first meeting I went to in the boardroom of Customs and Excise, the chairman of the CBI tax committee said, oh, well, you'll know the sort of people you're dealing with, because when you get into the boardroom, you'll find there are cutlasses on the wall. And you know, so the Customs and Excise had extraordinary powers wide powers, because of course they were all granted in times when, you know, they were having to fight smugglers bringing brandy in, you know, in places, remote coves in Cornwall and things like that. And when, you know, you need a cutlass just to deal with these sorts of smugglers and so on. But, you know, nobody took those powers away. So I'd almost said, once granted, a power's never likely to be withdrawn. I'll say it's quite unlikely, at least in... why give up a power when you've got it? Powers are generally widely cast and contain an element of discretion as to how and when they're exercised, and my view would be that there has to be effective oversight of the exercise of that power, not just internal. Of course, there are procedures within the revenue, and I'm sure Abel will tell us more about it as to the constraints that are imposed on officers who want to use these powers, but actually it ought to be a given that there is external control and oversight of those powers. It's something that is taken absolutely for granted in virtually every area you care to mention, whether you're talking about professional conduct, whether you're talking about the conduct of the City of London, whether you're talking about the conduct of the police. Why is it not true in the case of the revenue? It ought to be. My final point would just be the power's only as good as the law that it seeks to enforce. The law has to be clear and there have to be effective appeal rights, and actually if we have a major problem in this country, it is that our law is increasingly confused, unclear, incomprehensible, and coupled with that we've seen a number of instances where appeal rights are restricted, which I would say is wrong and which are heavily criticised in the House of Lords report. Thank you. Thank you.
Edward?
I will speak from here because I don't have any of this sophisticated technology. When I started out for this event, I thought we were having a debate, but there was a bit of interest on Twitter, and some commentator, who I think may or may not be here, I don't know who it was, said, I expect there will be a lot of people need to take personal responsibility, combined with a liberal sprinkling of HMRC have a tough job to do. Shall I make up a bullshit bingo card for the evening? So I'm not going to disappoint whoever it was. You know, if he expects me not to talk about responsibility and the tough job which HMRC have, you know, he was going to be right first time, and I will, as well as a few other things he might have on his bingo card. Excuse me. I then went back and looked. In fact, I had a lot of trouble getting hold of it because it's not been digitised. The Keith report on revenue powers, the Revenue Department's powers, which was 1983. And I have to say, I'm sorry, I don't think John Avery-Jones is here, but John Avery-Jones, who, as many of you know, is still an active member of the tax community, was a member of the Keith Committee in 1983, and he commended it to me. And I have to say, it is very commendable. I've given Helen a copy of the principles, which I, with my own technology, I've digitised, and they're well worth reading because they've stood the test of time quite well. But there's one quote from Keith which struck me. Which is this: enforcement powers are of their nature onerous, and their exercise can in certain circumstances bear heavily on the taxpayer, whether individual or corporate. A certain amount of friction and even distress to individuals is perhaps inevitable. And I thought those were very wise words, because while I don't really disagree with much that Malcolm has said, you know, his core point, which I do agree with, although he didn't put it quite like this, is that whatever the revenue's powers are, they should not be excessively burdensome, they should not be intrusive, and they should not be unfair, they should not be perceived to be so, and they should not be exercised by HMRC in a way which is excessively burdensome, intrusive, or unfair. And it seems to me we probably will all agree on that, although, as Malcolm said, there's quite a lot of debate about what those limits are. But what Malcolm hasn't said, which seems to me is quite an important point to start with, which is what should the revenue's powers be? And how do we test whether they've got enough powers? Now, obviously, should have said at the beginning, I'm speaking entirely as a personal capacity, and to the extent that anything I say is agreed with by HMRC, I'm representing HMRC, but otherwise I'm speaking on my own behalf. I would say, you could say, well, look, there's a tax gap in this country. We lose about 30 billion of tax, doesn't get collected. So clearly, revenue haven't got enough powers because, if they had all the proper powers, they'd be collecting all the tax. And Malcolm quite rightly said that, what should the taxpayer be doing? He should be paying, or she should be paying the tax due. But that's clearly a bit simplistic. And I would say that the starting point for any of this, and in a sense it's a societal judgment, is that the revenue's powers need to be sufficient to keep the tax gap at an acceptable level and this is a very important and, to maintain the confidence and trust of the tax-paying public at large. And I think that is the test which should apply to the revenue's powers. Now, that doesn't imply any judgment about whether it's there are too many or too few, but I do think the outcome of what the revenue do is that should be the determining factor of whether they've got sufficient powers or not, while taking into account the points about burdensome, intrusive or unfair. And I think there's a point to debate there. Now, Malcolm, in a sense, has made the next point which I was going to make, which is whatever the powers are, there must be clarity both about what the HMRC's responsibilities are, but also what the taxpayers' responsibilities are. And I don't think Malcolm disagreed that taxpayers do have responsibilities, and there's a point of debate about what those responsibilities are. And I also completely agree that there must be adequate oversight, and Malcolm, I think, mentioned this by implication, there must be adequate redress to taxpayers, because oversight is one thing, but actually, and I'm delighted that although Kelly Sizer's not here, Helen McGarry, the adjudicator for HMRC and for a few other organisations, is here tonight, and I hope that Helen may, in a sense, on behalf of the hard done by taxpayer, and there are quite a few, say something both about to illustrate where the powers go wrong, but also perhaps what redress is appropriate where they do. So I think there is some, I agree with Malcolm, that responsibility of taxpayers and oversight and redress are important factors. So the first question, or first group of questions, is, do we think HMRC's powers adequately reflect where we are at the moment? And there's an obvious point there about we are where we are, we're not where we were 100 years ago or 200 years ago, we're not using cutlasses to collect tax, or not at least in anything I've seen done. But there are a number of things which have gone on over and continue to go on in the way tax is collected, which I think do affect the powers. And the first of them is, in a sense, the one implicit in the cutlasses, that over the last 200 years, and apologies for those of you who've heard me give this little speech before, tax collection has moved from enforcement, simply more or less bashing down the door and saying, give me your tithe, or going onto the ship and saying, I've counted 500 barrels of beer, I expect this much payment, an enforcement culture to a compliance culture where the expectation and the starting point for tax administration is that taxpayers will comply. HMRC will give you the facility to pay your tax, whether by self-assessment or through PAYE or putting in your VAT returns or whatever it is. But the starting point is compliance, and enforcement is a secondary factor, both to deter and to collect from the recalcitrant. And I completely agree with Malcolm that the powers still, to too great a degree, reflect an era of enforcement rather than the culture of compliance. So I think there is the first point there is, in a sense, the lag in the development of powers. The second way in which I think the tax system has changed, where the powers should be tested, is that the computation of tax liability has shifted over decades, if not centuries, from based on easily determined numerical facts, how many barrels of beer have you got in this ship which you have docked, to more complex questions, which may still be, and they will ultimately be numerical because it's about the payment of money, non-numerical issues, which are, for what purpose did you incur this expenditure, what is the nature of your business, what your accounts look like, which are not capable of determination by knocking down the door and counting anything. You require information, and very often you require subjective information. Why did you buy this yacht for your business? Was it a business expense? Why did you enter into these complex transactions? Was it for the purposes of avoidance of tax? And the powers needed to determine that subjective liability are very different from the powers needed in order to determine how many barrels of beer there are on a particular cargo. And finally, and a bit sort of broader, we've seen over the last, well, again, Malcolm is the expert, a period of time, a growth in public administration law, and alongside that, public expectation. And again, the courts, will always find ways of reviewing the actions of public bodies. And I think I'm agreeing with Malcolm's last point that, in a sense, we have relied too much on, as it were, the growth of general public administration law and not thought specifically enough about what public administration provision should be legislated for or provided for, specifically in relation to tax. So those are three big areas: the shift from enforcement to compliance, the move from numerical to more subjective, and the growth in both public expectation and public administration law, none of which I think have been adequately reflected in the shift of powers. So there is clearly something which needs to be addressed here. But there are also, sitting here in 2019, a number of changes which I think both provide quite specific topical challenges, but also opportunities for the way tax administration is exercised and powers are exercised. The first point is the obvious point that far more information is held digitally, which means it is not held physically by the taxpayer in his or her home filing cabinet. It is held on systems, and often it is held by third parties. Now, from a tax administration perspective, there are huge opportunities, and I will not digress at this stage of the evening on what those opportunities are to enable HMRC to collect tax much more efficiently and with less involvement of the taxpayer. The taxpayer can just say, yeah, that's right, let's get on with it. But the powers for getting third-party information and the use of that third-party information are, again, lagging. I think there is a real opportunity, and I think there is a discussion to be had about the extent to which HMRC should both transform to use third-party information, but also what are the scopes of the powers to obtain third-party information, principally digital information. The second point is the concept of private information and privacy is changing and has changed significantly. A lot of the limitations and extent of HMRC's powers, inland revenue powers, and indeed to some extent the old customs and excise powers, were predicated on a sense of the threshold of the home, that only in extreme circumstances would the taxman or taxwoman actually, as it were, come into your home and start asking personal questions and rummaging you at home. And I think we probably all accept that there is a threshold, as it were, literally a threshold, over which in normal circumstances the taxman should not pass. But the concept of privacy, the concept of private information, the amount of private information which people spray out into the digital ether calls into question as to where the boundaries are between genuinely private information, which HMRC should not get, and private information, which just happens to be sprayed all over Facebook. Well, is this still private information? What are the extents of the powers which HMRC could use? Both for good and ill, if you like, both to help you. Well, I've seen that you've been doing all this and that. Actually, have you realised you can take advantage of this? Look at your Facebook page. But also, actually, what the hell were you doing having your 4th holiday in Barbados when you, claim to be, earning 20,000 a year as a hospital assistant? So there are some quite interesting questions about powers there. And finally, and in a sense there's a degree of judgment in this, I do think there is an erosion of the sense of personal responsibility for one's tax affairs. The fact that it has become quite easy to pay your tax without doing anything, either through PAY or through other means, it's the pre-populated returns, means that there is just an erosion of the sense of the responsibility citizens feel for their own tax affairs. And I don't want to get too much into that, but I think that is something where the reality of what goes on out there and expectations is different from the powers. So, conscious that I think I've just passed my 10 minutes, do I have any suggestions? Do I have anything where I think there could be discussion? I haven't talked about the use of discretion by HMRC, but of course HMRC uses discretion. It makes a discretion as to what question to ask a taxpayer. It makes it exercises discretion in deciding how far to pursue a particular taxpayer. It exercises discretion in deciding whether to have a campaign against scrap metal dealers or professional barristers or whatever it is. So a tax administration always exercises discretion. And I agree with Malcolm, not that there shouldn't be that discretion, but there needs to be more transparency both over the circumstances that discretion is exercised and how it's exercised, with some debate about whether there needs to be some greater redress and review oversight mechanism. I do think that we need to look carefully and give HMRC more explicit powers, both to question facts from third parties, to go to third parties and ask them what's going on, and this I'm picking up some of the points about promoters, and to involve them more directly and penalise them more directly where appropriate. The third point I had, and I think I probably covered this already, is about the transparency over the use of discretion. I've covered that as well. So those are my sort of thoughts about where we should be looking at more or different powers. I have one very specific suggestion, which I think can be implemented immediately with a little bit of resource, and HMRC do not have enough resource, and that is part of the problem, and I will take that as the bullshit bingo score on that. And that is that when new tax measures are published, there is a tax information and impact note issued, the TINs. Now, I don't know how many of you read them, but you should read them, but they are actually very informative and a lot more informative than reading the finance bill or the Chancellor's budget statement. I would suggest that within the TINs, there be a statement both of the way in which HMRC are actually at a practical level going to apply it, and some assessment of the nature of the taxpayers against whom it will apply and the approach we'll be taking. And I'm thinking specifically of the row, and I really, really don't want to get into this afternoon, the loan charge, where I think part of the problem is not that it's not doing what was intended, but what was not understood is what was the nature of the individuals and the mindset of the individuals against whom it was addressed. And I do think that might have been addressed, or there might have been more awareness of that if the TIN had put a bit more in about what HMRC knew about the taxpayers and how it was going to address them. I shall stop there.
The door opened there, and I was sort of hoping that it might be Nikki, but she's not here yet. Before we get into a question and answer session, I thought I would cover some of the points that poor Kelly would have covered, I'm sure, much, much more elegantly than I will. Those of you who know me know that I spent the greater part of my career in HMRC and Inland Revenue before it. In the last perhaps 3-4 years, my attitude towards how HMRC operates has hardened quite a bit. In part, that's through my own client work, because I see a number of times when HMRC is operating in a way which I don't think is the appropriate way for a tax inspector to apply their skills. But also the work that I've done over the years through Tax Help. I don't hesitate in saying I've seen some shocking cases. I recall a situation where I arrived at an old man's house in Chelmsford at the same time as the bailiff. And the bailiff said to me that there was nothing in the house worth taking. And there were some things on the van that he actually thought he might give this old bloke to try and make life a little bit more comfortable for him. And of course, with me being Glaswegian, bad temper is not particularly far from the surface at appropriate times, and it came to the fore then. And I would like to say that in that context, i.e. Tax Help, that's the only time that I've seen that situation. But almost every case that I've gone out with on Tax Help has been like that. As Kelly puts it, things will always go wrong. And there's lots of buzzwords that fly around here. You don't need to make a drama out of a crisis. HMRC used to say that tax doesn't have to be taxing. But the point they miss is that life almost always is. And life for a large number of people in this country trying to make sense of tax rules that they just don't understand and have no hope of understanding is just incredibly difficult. And I think we also need to avoid confusing two things. HMRC's powers by reference to statutory provisions are very powerful. They've always been powerful. Even in my day, they were powerful. I have a slightly odd claim to fame. In 31 years, I only ever issued one statutory information notice because I didn't need to. You know, I mean, I sort of, at the time, I was kind of sheepish around that because I worked in various parts of the revenue where they would issue them. You know, they were going out like confetti at times, Section 20 notices as they were, and I didn't need them because I used to go out and get whatever I needed, and even legally privileged information, no problem, because it was how you explained it and how you interacted with the person on the other side. Did that mean that I didn't from time to time run up against a problem? No, but more often than not, I could find a way around it. But the key to me as to where HMRC is at the moment, it's not the statutory powers they've got. I mean, Malcolm, obviously, and Edward to some extent, and there are other lawyers in the room could say, well, HMRC has become too powerful. But it's the practical application of the law and the powers that's the important thing. And if the officer just closes their eyes to the problem of the taxpayer, the problem of the issue, then that's where it all starts to go wrong. Kelly has highlighted a couple of cases. One is Sandpiper, involving an individual who suffered from Meniere's disease, and as a consequence of that, had become profoundly deaf. And HMRC apparently continued to tell him that he should contact an HMRC helpline to try and sort out his problems. The other one is Mr., and excuse me a second because I'll get the name wrong, even though I wrote about it a couple of weeks ago, but I don't want to get his name wrong. Is Mr. Pokarowski. Now, Mr. Pokarowski was taken to the first-tier tribunal for a £100 penalty plus some daily penalties in circumstances where he was homeless. Now, one of the people that worked beside me is a former very senior HMRC barrister, and he put a cost of a first-tier tribunal of that nature at £20,000. Now, are we seriously in a situation where HMRC should spend or cause to be spent around £20,000 to try and collect a £100 penalty? I've seen some of the situations where HMRC has denied reasonable excuse. And, you know, they seem to do, I mean, it seems to be an almost unreasonable denial of reasonable excuse, the way HMRC try and rationalise it from time to time. And last week I was at a meeting with HMRC where they explained that they are now going to delay issuing the £100 penalty notice. And they're going to delay that because they don't have the resources. Now, is that a reasonable excuse? Because that's usually the problem that many taxpayers face in terms of getting their tax return in by the 31st of January. And I mean, I've mentioned in the past, there are just too many people who fail to get their tax return in by the 31st of January. They can't all be bad. A fair proportion of them, probably a high proportion of them, are, you know, facing up to coming back to the point I made at the start, that life sometimes is too difficult. And you forget, or you can't get the information, or you can't get online at the time, and so on. And simply having a very kind of black and white, well, it's not in £100, you know, and then you start spending huge amounts of money trying to collect it. And it would be interesting to see what the data is in terms of how much of the £100 penalty is spent. So that's most of what Kelly has said. And it kind of segues into a question that Keith Gordon had put to me in advance of this, which I think might be a good way to sort of kick off a little bit of a Q&A. And Keith referred back to the BPP case. And you will recall that was the case where HMRC was prohibited, if that's the correct expression, from arguing its own case in front of the court because it had failed to comply with directions. And he referred to Lord Neuberger's comments where he said, it seems to me that there is at least a strong argument for saying that the court should expect higher standards from public bodies than from private bodies or individuals. And Keith, on the back of that, has posed a number of questions which perhaps Malcolm and Edward could think about. Do the panel members consider that Lord Neuberger's aspiration to apply in all the dealings of a public body and not just when they are litigating? Do the panel members feel that HMRC commissioners and officers meet the appropriate standards on all occasions? And finally, can standards be lowered when combating certain types of behaviour, such as evasion or avoidance? And just to finish this point off and come back to my experience, I was fortunate in a lot of ways. I worked in the best parts of the revenue. I worked in Special Compliance Office, Special Investigation Section, in various other places, the Large Business Service, working on banks. And when I look back on it, the one thing that actually gave me, above everything else, I mean, it gave me lots of things, but the one thing it gave me was to be able to see the wood for the trees in terms of what's important and what's not. And in a tax context, HMRC will always be hard up for resources. It doesn't matter how many people they had. They had 100,000 at the point I left. They've got a lot less than that now. You could double the number. They will still struggle at times to be able to resource everything they want to do. And you have to make choices. And the one thing that HMRC seems to have done over the last 10, 12 years is try and drive a situation where HMRC officers don't have to make those choices, that they can just take everything on. And we see the consequences of it. I've got a client, I've only been involved in it 2 years, 2.5 years. They've been under inquiry for 15 years. A settlement proposal put in almost 2 years ago has never been responded to. And I'm sure that client's not alone. In fact, I mean, I know that there are thousands of cases that have been there for years and years and years and are not, effectively progressing. And the evidence last year given by HMRC to the Treasury Committee put the number of open cases at 80,000. And I think we all should be worried about a situation where the number of cases on HMRC's plate just goes up and up and up. And frontline inspectors seem sometimes either unable or completely devoid of a basis upon which they can try and move these things forward. That's Kelly. With a bit of help. So perhaps we could throw it up to questions now, and Edward and Malcolm and anybody else can join in. And there are a number of HMRC people in the room, so a little bit of respect would be good, but I'm sure this is such a lovely audience that there's no risk of worrying about that.
Shall I, while somebody gets a microphone to one of the questioners, because Sam, I think, was done here. Let me just comment on one thing that Edward said. He said I hadn't dealt with what powers the revenue should have, and I didn't, because I don't actually think that's necessarily a question that can easily be answered in the case of a debate like this, whereas I think actually focusing on what the degree of supervision of the revenue should be is a more, well, I would say it's the more immediate and relevant question to ask. But I we
decreted powers which shouldn't have. Sorry,
I was taking.
You've got to say that we've got to be able to take some away.
I was taking the way in which powers have accreted over the last 5 years. Now, what I do think, actually, you could say, is that there should be a greater degree of, or greater burden put on the revenue to demonstrate why they need additional powers when they come to seek them. Because, as I said in my remarks, in a sense, they get whatever they put before Parliament. The question is, have they really justified what they've asked for?
I completely agree with that. And I mean, I think the TINs are not going as far as that, but it's something you could do without any real change, and then you could move, as you say, into actually putting more explicit justification for new powers, as well as an explanation as to how they would be used. So I agree with that. But I do think, sorry, just coming back to my challenge, if you say that, I don't disagree there are too many powers, but I do think it's incumbent on us and this audience to specifically say what powers should be taken away if we think that it's about the scope of the powers rather than the exercise, which I think is Ray's point, and the lack of oversight and redress. Yeah. But in a sense, I'm quite happy to move on to that. But we have to decide whether we're accepting the powers as they stand and moving to oversight, redress, and transparency of exercise, or whether we actually would like to push some of the powers back, in which case we need to be quite specific about which ones should go.
Yeah, I mean, in my day, HMRC could enter premises, HMRC could issue notices requiring individuals and third parties to provide information, documents. So the general framework of what HMRC can do today is pretty much the same as it was throughout the time I was there. The big difference today is that so much of that can be exercised by HMRC with no supervision by anyone other than HMRC. And as things stand at the moment, it's not obvious to me that HMRC supervising itself is necessarily what we really need.
Can I throw a question in, actually, which I realised looking at my notes I failed to put, which is that, one of the problems, and again, looking at some of the situations at the moment, is about the way HMRC exercises powers, and that it does not take a sufficient account of that this person really didn't know what she was doing or he was doing, or this person was very canny, even though the actual factual circumstances are otherwise the same. Do you, Malcolm, or anyone think that that is a differentiation, one which should be made by tax administration, because in a sense it breaches the rule of equity and equality under the law. And if it should be, because you're sort of implying that it should be, is that something which should be done by reviewable exercise of HMRC discretion, or should there be legislation to effectively say HMRC should apply these powers differently in circumstances where you've got someone who knew bloody well what she was doing, from ones where actually they were innocently duped into a tax avoidance scheme? So, and in a sense, I think those questions come out of some of the debates, which I'd rather not have about the loan charge. But there are quite a lot of layers of question as to how you deal with that, which I think it would be good to try and get out.
Yeah. Okay. I think we've got some microphones. Sam, we've got microphones? Yeah, we've got lots of hands there. So closest to the microphone.
Paul Hudson, thank you very much. You've had two main speakers. Sorry, can you hear me now? Right. Thank you very much for the two main speakers. It's quite an eye-opener. I don't regard taxes as a burden. I take the view that the Scandinavians take, that taxes are all part of the social wage. I say that by way of preliminary. For a number of years, my tax affairs were dealt with in Cardiff. I think people who'd been retired from lecturing or teaching, in fact, had all their affairs dealt by this office. But about 3 years ago, my affairs were dealt with by a tax office in Bexley. What is interesting, they gave the postal code, but they didn't give the town and they didn't give the street of the tax office, which I thought was strange. But what disturbed me, I should point out that my pension is actually almost up to the average wage. I don't run a car, but I'm paying, in fact, 60% of it goes on financing my granddaughter's education. Now, I didn't know I could claim tax returns, in fact, tax rebate on that. But when I asked, in fact, it's quite by chance, I learned from an accountant, he said he would claim me tax relief. I said, I didn't know you could. Now, when I asked the tax authorities in Bexley to send me my tax, a pro forma for the tax return, they said, you don't need it, we know all your tax affairs. And I wrote back politely and said, well, they've changed since I last spoke to you. I said, I'm financing my granddaughter's education. I said, would you please send me the form? And they didn't. And then I sent a chase up, and they didn't again. So I then had to go to the local tax office in Croydon. They were reluctant to, but eventually, after I persisted, they ran off the pro forma for me. For the last 2 financial years, I've provided all the receipts, in fact, for the fees I've paid to for my granddaughter's education, but these are not taken account of in the in my tax returns. They said you need to get some advice from a tax accountant. I said, well, I've already received one, but I don't know whether it seems to me impolite or arrogant. I don't know whether this is typical of the new regime. With Cardiff, I had very, very cordial relations with the tax inspector. Everything was amicably settled if there was anything outstanding. I don't know whether my case is typical or not.
Okay. Sam, maybe take 2 or 3 questions at a time, and that will probably make it easier to fill in.
Hi, it's Simon York. I'm Director of HMRC's Fraud Investigation Service. And given the numerous mentions of smuggling and that I'm the director in HMRC that is responsible for tackling organised crime, I thought I'd first of all confirm that we no longer use cutlasses. However, smuggling does cost the UK Exchequer an awful lot of money still, and is driven by very sophisticated, ruthless and quite audacious organised crime groups. So it's a massive issue. But 2 quick points from me. First of all, if we look at the tax gap, we estimate a significant proportion of that, more than 1/3, comes from what we would probably describe as dishonest behaviour. So criminal attacks on the system, evasion, hidden economy, etc. So people who've chosen quite deliberately not to tell us what we need to know or to lie, and I think that's got to be taken into account in the balance of powers and privacy. And the second point is really just to pick up the external oversight point, and Malcolm's example, particularly about the police there. Well, actually, we have exactly the same oversight as the police in relation to our most intrusive powers. So search warrants we need to get from judges. Some of our most intrusive powers we have to get from the Home Secretary. We're overseen by the Independent Office of Police Conduct, HMRC, the Investigatory Powers Commission, who cover all the Facebook stuff, actually. So that is overseen by us. We have a statement on our website as to what we do there, but that whole policy is overseen by the Judicial Commissioners of the Investigatory Powers Commission. So I don't think that gets sort of said enough that we do have an awful lot of external oversight, both on a power-by-power basis and a sort of regular, very, very rigorous inspection basis.
Sam?
Thank you. Sam Mather, former revenue official and a member of Malcolm's Tax Law Review Committee. One of the things I've been puzzled about, the discussion so far has been very impressive, but one of the things I'm concerned about is the relative absence of any reference to the political dimension in the growth and nature of revenue powers. The fact of the matter is that all the legislation we're talking about here was enacted by Parliament. And in a sense, the fact that we're here discussing the risks caused by arguably excessive use of revenue powers is a sad reflection on the poor quality of scrutiny by Parliament of not just the complexity of the legislation, but the sheer volume of it. Now, at times, and I plead guilty to having been responsible for some of the items that Malcolm listed as problems, it's almost as if the revenue's been given a blank check because ministers are frightened of actually denying the revenue powers for fear of being thought soft on tax avoidance. People in the opposition parties and others who've got concerns about revenue powers are very ably briefed by the professional institutes if they lack the knowledge themselves. But very often they're fearful of actually expressing them too stridently or forcibly because of the fear that they'll be demonized by the social media as being people who are supporting tax avoiders. So it'd be really worth hearing what Malcolm and Edward think about the political dimension.
Hi, Tom Smith, Director of Tax Strategy at HMRC. I just wanted to make a couple of sort of general points as opposed to, because there's a lot being said tonight, and I think it would be wrong to try and go into sort of point by point. I mean, first thing, some of you may have noticed there are quite a lot of us here tonight, and I think that's a good thing because it shows how strongly we are listening to this. This is a really hot issue. We are listening very hard, and this will continue to be debated very hotly within HMRC and taken very seriously as we go forward. Second thing, there's some of the comments that people have made tonight are about occurrences where we have very clearly, despite our efforts, got it wrong. Where we've not done what we should have done, we have not exercised our powers in the right way. There is a lot we do to try to, as Jim Harrow and Penny Chernevich recently set out to the Treasury Select Committee, to try to control all that. But we're a huge organisation doing lots of things. We don't always get it right. And this is something that we will continue to battle with. Third thing, I was quite interested in Sam's comment about Parliament ministers being too scared to block anything we want to do. I think all I can say is it doesn't quite feel that way to us. And equally, don't count on Parliament to limit HMRC's powers. What I would say is the things that you see coming before Parliament are the ones that we've actually managed to persuade ministers to. There is stuff that doesn't make it, let's just put it that way. And I think any suggestion that it's easy to get through things through Parliament right now, again, not quite how we see it. Finally, just a plea. It's absolutely right we should be having this debate. What I can say is the more the debate can be pitched in terms of, yes, you guys do have a tough job to do, but the things that are needed for us all out here to have confidence in how you do it are these. I think the more traction it will get, the more we can find common ground. But this has been a really interesting debate, and I really look forward to hear what others have to say.
Thank you. Hi, Paul Johnson, IFS. I think there's a really interesting of appropriate revenue. And I guess my question to Edward is, well, given that people do have these legal rights and we really don't want to hurt them, what are the processes and oversight you'd put in place to make things better and put people's minds at rest?
I'm conscious that there are five people have commented, so I'm not sure whether to try and deal with everyone or start with Paul. So, but actually, can I just pick up the gentleman at the first point who was complaining that there wasn't an address, there's a postcode with no address, and he didn't have an office. And I think there's, in a sense, I will slightly, talk on behalf of HMRC here. Driven by reducing resources, driven by the need for efficiency, it is far more efficient for a national organisation effectively to have one address to which everything goes and then field it out to wherever the resource is to deal with that and deal with it, rather than to have lots of little local offices, if you like, sort of cottage hospitals rather than one big health facility. And that's what's happened. I like to think that HMRC recognises that actually the pendulum swung too far across, to the sort of mechanisation and the fragmentation of tasks in the name of efficiency, and that customer service did suffer, and that actually over the last 2, 3, 4 years, the pendulum is swinging back a bit more towards customer service. So I just sort of say, I recognise what lies behind those concerns, not to say that you probably haven't had a bit of a shocking time, but that I think the pendulum is moving back slightly in your favour. But can I then jump on to Paul's point from there? Where I thought it was a good job. I used to slightly forget that I was a lawyer once upon a time, but and I think Malcolm and I would agree that once a lawyer, always a lawyer. But in a sense, what that point picks up, and in a sense, why is tax such an extraordinarily interesting topic? Because it is, the legal topic, par excellence. There is no equity about a tax. It is only what the words of the statute say. We believe in the rule of law. We believe in equality under the law, and things need to work according to the law. Yet, it is something which impacts so directly on individuals, for which individuals get no direct return, and obviously it's highly politically sensitive. And in a sense, this is the essence of the challenge of tax raising. And I think in a sense, your question has brought out the point that yes, tax has to be collected under the clear letter of the law in a way which is fair and equitable, but we know that the great diversity of humanity means that a one-size-fits-all approach to tax administration creates real pain. And I'm sorry to come back to the loan charge, which I said I didn't want to talk about. That's exactly what the problem is, because there's been such a diversity of individuals within that applying the one-size-fits-all has been very painful in a number of cases. I think the answer, and it's sort of slightly, I think, part of Sam's point, that actually when legislative powers are given, they need to take more account of the reality and the diversity of human nature, and therefore not to be excessively targeted on one set of population without regard to how that might work more widely. So it is about better scrutiny, which I think is sort of Malcolm's last point in his slide about laws being better. But I think there are then some serious questions as to how does HMRC, the point I made a few minutes ago, how does HMRC exercise some degree of discretion? Is it under some sort of legislative basis, or is it using the inherent administrative discretion which they have, in which case Malcolm's point, how do you review that in a way that the system continues to be seen to be fair and there is adequate redress in individual cases? So, I mean, I think your question, Paul, goes absolutely to the heart of the challenges here, but I'd sort of like to hear Malcolm's views on that. And indeed on the other points.
Well, Edward, again, I won't necessarily pick up all the points, but you asked, I think, was whether or not you could treat taxpayers differently in relation to the same sort of set of powers. I think that was. Well, I have to say, isn't that an element of discretion? I mean, that is, using your judgment to decide how you should operate a set of powers and flexing that according to the person against whom you're using, that is an element of discretion. Ultimately, whether or not you're exercising your discretion correctly in any particular case, or let's say across the broad spectrum of things, because I appreciate this is a huge department with lots of people, and as we've heard, quite rightly, not everybody's going to get it right all the time. But it's a matter of whether or not there is adequate external scrutiny to see that that is working correctly. In other words, that as a general matter, the powers that are being exercised properly and in a manner which commands general support.
But so general support by the people out there, or by the law? I mean, this is Paul's point.
Well, so of course you want tax law to be certain. I mean, so one of the sort of bases of the rule of law is that people know what the law is and therefore know what their rights, responsibilities and obligations are. And that's the ideal you aim for, and which we frequently fall down on in many ways in the tax system. But within knowing what that is, whether you're going to actually impose a fine or a penalty rather on a particular taxpayer and then go and try and collect it in the courts and so on, that's a matter of discretion. I mean, you can't just operate a system on the basis of even if the person happens to be sleeping rough and doesn't have any money or doesn't have currently any money to pay the tax, yes, we'll go off to the tribunal and spend £20,000 trying to recover money that he hasn't got. I mean, that's an element of discretion as to whether or not you're going to exercise your powers in those particular cases. And I don't actually see that when I say as a big issue. I mean, of course it's an issue, but the question is whether the department as a whole is correctly using its powers in the way which commands support and which doesn't lose the support of taxpayers generally. I wrote a piece on tax avoidance and the rule of law more than 20 years ago. And actually, I looked up to see how I started it, and I said, I imagine the earliest methods of taxation involved no more than a demand for money backed by the threat of force against prospective taxpayers or their property if they failed to pay. In a democratic society, governments legitimize their demands through legislation. That's what they do. You have to legitimize what you're doing in a world where it's very difficult to get it right all the time. And oversight as to how your tax collecting authority is running is one of the key elements to that, which I don't think we've got right in this country yet, or certainly not in this is what we need to have the debate about. And as I say, why I didn't go into what the power should be, and I thought, I don't know, I'm not sure I agreed with Paul's characterization of what I was saying, because ultimately, would we, supposing you legitimized by law a rule which said the revenue could write to a taxpayer and say, you owe us £500, and if you don't pay by next Monday, we're going to come round and beat you over the head. Now, would we think that was acceptable? That was the poll tax, I think. We wouldn't think that's acceptable, and you can get very wound up about the rule of law and things like that, but the fact that you walk out into the streets every night in this city, and generally speaking you're right, despite the terrible increase in knife crime in London and so on, is all to do with respect for the law and the way in which the law is enforced, and that's why lawyers get concerned about this, because ultimately we don't want a system where Parliament passes a rule which says, if you don't pay £500 by next Monday, we're going to send the bailiffs in to collect it. without any more. That's pretty fundamental stuff, really. We shouldn't just sort of say, well, you know, we've got to think about whether or not, you know, from an economist's perspective, we should, that's appropriate or not. It's not appropriate. But at the same time, so we have to have a system which commands general support amongst the population. And seeing that the revenue collecting authority is exercising the sorts of discretions that it needs to be able to run a tax system in an acceptable manner is a very important element in that.
Edward, coming back to the point you made, that there's no equity in tax, which has long been said, there does seem to be an increasing number of voices out there who hold the view that HMRC goes for the maximum amount of tax, irrespective of whether the maximum amount of tax is the right amount of tax. And likewise, when it comes to statutory construction, any version that matches HMRC's is accepted, and anything that deviates from HMRC's is rejected fully. And I suppose probably the main concern that I've got in terms of how we're ending up in situations like Mr. Puckarowski and other cases like that, is that within HMRC there's a culture that unless they believe that the taxpayer's position is rational in law and can be, you know, justified, they are duty-bound to resist it regardless of the merits of the case, regardless of the circumstances of the taxpayer, and regardless of the amounts involved. Because it seems to me that is the only thing that can be justifying or explaining how so many of these cases are ending up in front of a tribunal judge and resulting in, I mean, Richard Thomas, as you know, is an ex-HMRC inspector, and he has been one of the most virulent critics of HMRC in terms of the comments that he's made. Puckarowski's case described as a scandal. We shouldn't have tribunal judges making these kind of comments.
No, I will defend HMRC, although that's not what I've come here tonight to do. I don't recognise your characterisation of the ethos being about maximising tax or taking arguments, and ignoring all other arguments. And the process which I was responsible for establishing, the Tax Assurance Commission process from a top-down basis, did give effect to the litigation and settlement strategy, which effectively said HMRC will collect the right amount of tax under the law, in the light of the legal advice in each case. Now, obviously, when you filter that down to the 750,000 settlements which the department does in every year, I'm not going to swear that every single inspector everywhere does that without a bit of pressure one way or the other, but I do think by and large that is adhered to. The maximising tax, I just don't recognise it. And if I can make a slightly cheap point about the tribunal chair you refer to, I think, and I, always, happy to be corrected on the facts, he's been overturned on appeal more than any other tribunal chair. But I'll take some statistics on that after the event. But let's sort of hear what others got to say.
Let's get some more questions. In the middle there? Glasses?
Thank you. I'm Helen McGarry. I'm the independent adjudicator for HMRC. So thank you, Edward, for setting me up. I did want to say a few things. I think that one of the things that you just mentioned there, Ray, was the issue of culture. And I think listening to some of the things that you've been talking about is quite interesting, because reviewing complaints against HMRC, I don't so much see this issue as one of the, through the perspective of legal powers or even necessary exercise of discretionary powers, but from the point of view of the cultural attitude towards the people that deal with HMRC. An enormous number of the complaints that we deal with come from people that are on low incomes, that are vulnerable, or just very, very confused about the situation that they find themselves in. And one of my observations about that would be that there is a bit of a one-size-fits-all approach from a cultural perspective. So there's been a lot of debate in HMRC about whether or not to call people taxpayers or customers. I don't think that that's really the issue. A lot of the time, HMRC makes decisions, takes actions, or sometimes makes mistakes that have massive impact on people's lives. And I think that what's important from the perspective of complaint handling, and sort of what I see from the complaints, is that HMRC take responsibility for that impact and have a view of actually trying to rationalise what that impact might be before it takes actions, rather than being driven by internal priorities in terms of their decision making.
Thank you. Sheila Page, ODI. I wanted to take up a slight point of difference between the two speakers. I was impressed by Sir Edward's point about the possible erosion of responsibility because of the way in which the revenue does all the receives information from third parties and then uses this information, which slightly contrasts with the idea, with the very short answer no, to the question of does the way in which auto-completion of returns now happens change the responsibility of the taxpayer. There is a difference between reading or not reading something which has been sent, which has been produced by someone else, which has been sent, and which frankly sometimes is very much you owe £500, pay it, or not hit you over the head, but hit you with some sort of an order. Compared to filling in a form saying, I had income of X from Y, of A from B, etc. And sometimes it works against, sometimes it works in the taxpayer's favor when the HMRC doesn't know what it's talking about. But I think that it's possibly worth getting some reaction between you of whether you think things have gone too far in terms of relying on third parties, not as checks, but as the only input to tax.
Michelle Robinson. I would be interested in hearing views on the taxpayers' right to certainty in their affairs. It seems to me that over recent years the law has become ever more complicated and often subjective to apply. And recent changes, such as the extension of offshore time limits to 12 years if you happen to have affairs in the wrong jurisdiction, means it'll be a very long time before taxpayers can have certainty of their affairs in often complicated areas, even where they have done their very best to comply. And even if it turns out they have behaved absolutely correctly, they can still be put through an inquiry which can last quite some time, even 12 years after the event.
One more? Yeah.
Dan Beanie, layperson and taxpayer.
We're all taxpayers.
The revenue doesn't wish to maximise the tax collected, but wishes to collect the right amount. So I suppose that's why the penalty regime was changed a short while ago, so that instead of starting at zero and the revenue having to justify what percentage they might wish to charge someone, it now starts at 20% or 50% or 80% or 100% or 200%, and the taxpayer has to argue the revenue down from said penalty. If the revenue's not trying to maximize what it's collecting, then I don't know what that is. But this goes along with your point as to should the revenue be allowed to use their expert psychological power to distinguish between different taxpayers' motivations and knowledge. Well, of course, we all know the revenue is so expert at their jobs already that they could easily assimilate this expert psychological power in addition to what they already can do. I think you have to be joking if you think that that's going to result in a fair system. Now, in the real world, because a lot of what you say is all very fine in theory, but in the real world, a taxpayer's lot these days is equivalent to being a character in a Kafka novel, like The Trial, say, or The Castle. So you may be sent a letter saying, you taxpayer, you owe us X because you didn't do the following correctly. So as a taxpayer, you read this and you really haven't got a clue what it means. So you try phoning up the revenue and you get a phone that rings and then cuts off before anybody answers at all. So you try phoning a few more times. If you're lucky, after about the 20th time, somebody might pick up the phone and then direct you to another number. And then you ring that number, and after 20 times of ringing that number and nobody answering the phone, you're going to give up. So you write a letter to the revenue saying, dear sirs, I've received the following, I don't understand it. You send it to the aforementioned address, which is simply a postcode. And if you're lucky, about 6 months later, you get a reply. And if you're lucky, the reply answers your question. But most of the time, it doesn't. So dealing with the revenue these days is, well, it's like dealing with mud. I mean, you get nowhere, basically. If you think you've been treated unfairly, and several of my friends do think this, you write to the revenue with a complaint. You put out your complaint in, what you believe are the correct terms, and after the aforesaid 6 months, you might, if you're lucky, get a reply, and the reply will say, we don't agree with your complaint. So you write back and say, well, I'd like it referred to your boss or a superior person at the revenue. So 6 months or a year later, you get another reply from someone who says, well, I've reviewed the complaint and it's baseless and therefore we're dismissing it. Sorry, we have decided you have no grounds for complaint. That is the stock way taxpayers, in my experience, are being treated today by HMRC. They have a lot of power. They're not really fulfilling their responsibilities at all. So I have friends who are in dispute with the revenue as to how much tax they should be paying. And some of them come to agreements regarding settlement terms, and they'll pay so much a month. And then the next thing that happens is a debt collector shows up on their doorstep, banging their door, saying, I've been sent by the revenue to take away your goods because you haven't paid your taxes.
But is there a question here for Malcolm and Edward? Because, there are other people who want to get in. And I have to be honest, in defence of HMRC, I don't ever remember a time when the revenue were ever good at answering all the posts. And in fact, I mean, I see there are some people here who were there when I was there who will remember the 1980s.
To reality.
But there would be people who can remember the 1980s when not only were the revenue bad at answering posts, that there were a number of times when they just didn't bother because it was just too big a task, there was just too much coming in. But is there a question, because I'd like to move on and get some more questions in, because we are starting to...
When might HMRC be capable of responding to customers' complaints properly? As a final comment, I'd say, given all of this, you could simplify the tax system at one stroke very easily tomorrow by abolishing income tax and capital gains tax in favour of IHT, because by the time you come round to collect it, everybody will be dead.
Right. Shall I try and...
Edward, you were going to come back.
Can I just come back to some really interesting points? First of all, thank you, Helen, for contributing. Big debate around culture. The issue of time limits I didn't mention, which is sort of linked to the question of, retrospection and retroaction rather than retrospection. Really important, really difficult issue as to time limits. But actually, the last two commentators picked up something I would like to pick up on, which is, you're absolutely right. HMRC should not use its experts to discriminate on whether they like this person or that person. And that is, the challenge, that we know people have different circumstances. How do you actually, in a sense, apply a fair system? So I agree with your concern that this is not realistic, but you talk to the people who are affected by the loan charge. There are people who've got the loan charge who are absolutely culpable as hell and knew they were avoiding tax, and there are people who got the loan charge who, in a sense, were duped. And this comes into the lady's point here. Third parties are involved, third-party advisors, as well as those circumstances completely outside avoidance, where third parties manage PAYE and get it wrong on behalf of an individual. And I think that there is a big challenge, and it's the point I was trying to bring out as to how much powers should take account of and be directed at third parties who either promote or administer tax affairs or enable tax affairs for others. I don't have an answer, but I think it's something we just have not had a proper debate on. So I think you're raising some good points. I'm not going to respond. Ray has made, I'm not sure I completely sort of go with the point that HMRC has always been as crap as this, and someone who's been around longer than me may tell me what the acronym was, which was written on filing cabinets well before I was in the department, which effectively said, never deal with these. But there was a three-letter acronym, and when you had the files you just weren't going to deal with, you put them in there and they eventually, something else happened to them, but the customers never got responded to. That does not happen anymore. Tony O'Neill may remember the acronym. No, he does, but he's not going to share it because he can't remember. But it did. He was there. He didn't do it, but he was there. Malcolm.
Which of those many points? I mean, just in relation to the time limits and so on. Well, I made my views known when I was asked by the House of Lords about that. I mean, it seems to me inappropriate. And the House of Lords report says that they were not satisfied with the reasons the revenue had put forward as to why they needed to have a 12-year time limit. And as I've already commented on the sheer difficulty if you get involved in an inquiry and an assessment over those sorts of periods that actually you have dealing with it. So I don't think I need say more about that. I mean, just as a general, I mean, my general perception, we can all think about cases which, where we think the revenue have got it wrong or acted inappropriately and so on. Actually, I'm usually very careful because my position, as a tax silk, and I'm mainly dealing with large corporate cases and things like that, or high net worth individuals and so on. You know that you're not necessarily seeing a representative sample of what goes on in the world at large. So I'm always careful. I try to be careful in drawing conclusions from what I see. I mean, and the point I've made, I'm going to repeat myself, I think, again. It just seems to me that to maintain confidence in the system, there's got to be some way in which you can see how this is going on as a generality. So, I mean, nobody's going to, I'm sure that the revenue themselves wouldn't be very happy, certainly at the higher echelons, with, the sorts of delays that this gentleman over here has been talking about, or the move from Cardiff and things like that. They're running a very large organisation which doesn't get it right all the time, as the gentleman over there quite appropriately pointed out. The question is how you maintain confidence in the system generally so that you can actually see whether these things are the exception or are the rule. When I say the rule, they are occurring too often for us to be satisfied with the way in which things are being run.
We've got time for one more very quick question. The back.
Thank you. My name's Alison Foster. I'm a member of the bar. It occurred to me, considering all the various things that people have said, that at the heart of much of this is communication. That a lot of the complaints, whether genuine or not, are about changes of policy, particularly with tax avoidance and schemes. You might be funding the film industry one minute, later on down the line, you're a tax avoider, and you're persona non grata. And I wonder if, both at that level, but also at perhaps a lower level, there could be more of a policy of communication of change as it's anticipated, when it's anticipated. Conscious this is in the hand of government and not in the hand of HMRC, but quite a lot of it is to do with telling the tax-paying public how they are likely to be taxed or what is under consideration for taxation, seems to me.
Before I get Edward and Malcolm, just to very, very quickly sum up before we finish, is there anyone who's got anything burning that they want to say? No. Edward.
No, this is such a rich topic to sum up. I mean, the tweeter, in a sense, was absolutely right. HMRC do have a tough job to do, and I'm going to say that, and he can give me another tick on his bingo card. And there are some choices as to how much HMRC is funded and what directions are given. But I would strongly prefer HMRC was not told just to exercise its discretion to get a sensible outcome. Does not feel right. Secondly, I was accused that I was also cited for the bingo card that people need to take a personal responsibility. I wouldn't put it quite as actively as that. I think the question of what responsibility individuals have, particularly in this day and age where so much can be done, as it were, by systems or by third parties, is a difficult question, and there needs to be a bit more explicit discussion of what responsibilities are expected of you if you're a PAYE employee, if you are a self-employed contractor, if you are a multinational. And I think there's something there. And then the third and final point, and thank you for the last question, is always good, and I'm sorry that Nicky Morgan has been irrevocably delayed, to end up actually pointing the finger at those who are ultimately responsible for the mess we have to administer, the parliamentarians. But, you voted for them, we voted for them. It is our responsibility as well as theirs that actually the laws are sensible and fit for purpose. And I certainly don't have an answer as to how we achieve that. But, we are voters and we should have a bloody good go at trying to improve the output of that place over there.
I did find it a little bit odd just before the end of the year, confronted by the Treasury Committee demanding that I explain to them why the loan charge was unfair, given that they had voted for it. But, Malcolm.
Well, just picking up on Sam's point and the last point that Edward made. I mean, in relation to our tax laws, when I say Parliament's been hopeless for as long as I can remember, I mean, it just does not have either the ability or the inclination to review our tax laws in the way that it should, and I'm not sure that that's ever going to change in the near future. Certainly hasn't changed in my time of practicing tax. If Nicky Morgan was here, we might ask her what she thinks that she should do about it, but we'll have to leave that for another occasion.
Thank you very much. Well, that brings us to the end. As both Malcolm and Edward alluded to, Nicky continued to be unavoidably detained, so we're not going to see Nicky Morgan tonight. Thank you also in absence to Kelly for the words that she sent through, which informed much of what I said. Judging by the various things that Keith has continued to send me through the course of this event, it seems to be the controversial word of the evening is maximise. Anyway, thank you very much for that, and if you could show your appreciation to Malcolm and Edward. And if you want to join us, I believe there are some drinks being served somewhere in this building. And I see an old friend of mine has just stood up and he's obviously leading the way to get the wine. Thank you.